This is case number 17-109-250. This is Bright Financial Services versus Kenyatta Gray. The matter is before the court on a subpoena to appear. That is secondary to an attempt to enforce a judgment that was previously entered in this case. Your appearance for Bright, please. For counsel for Bright Financial Services. Kenyatta Gray on this zone. Kenyatta Gray. Right, no response. The court will revisit that matter momentarily. The court now calls case number 21-170-612. This is LBNB Funding LLC versus Jacqueline Davis. Matter is before the court, set on for a scheduling conference. Your appearance for LBNB Funding, please.
Judge, may I please court? My name is Attorney Richard Rusin. My bond number 35222. I'm the attorney of the I'm the attorney of record today, and I'm pleased to say that I've settled this case, and I have in my hand a fully signed, stipulated order of dismissal with payments by signed by myself and opposing counsel, just so that the terms are quickly placed on the record. Defendant agrees to pay the sum of $600 per month. I'm sorry, $600 total, with $200 monthly payments beginning March 30th, 2022. If the payments are timely paid and paid in full, I will file with brother counsel a stipulated order of dismissal with prejudice. The order I have in my hand is without, and if there is any payment default, the plaintiff has reserved the right to file the appropriate documentation and the register of actions asking for judgment in the original amount of the complaint less actual payments received. Judge, I'm prepared to file this stipulated order with the clerk's office tomorrow morning when I'm going to be appearing downtown to do my filing.
All right, thank you. Do I have defense counsel on this show? All right. Thank you for the representation will be accepted at this time, and the court will sign the order upon its presentment. You can do that either by email or in person. Either way, we'll get it right back to you.
Thank you, Judge.
All right, good day to you, sir. All right, this is case number 21-166-227. This is Cisco Detroit LLC versus Deering Company Incorporated, doing business at Birch Marketplace. Matters before the court on an adjourned date of hearing. The court adjourned this matter to allow the defendant in this matter to obtain counsel as the defendant is a corporate entity. Your appearance for the plaintiff regarding this case.
For the record, Your Honor, Albert Kim, P70301, appearing on behalf of plaintiff in this matter, Cisco.
All right, thank you, counsel. Good morning to you, and counsel. Who is representing the Deering Company?
Good morning, Your Honor. Attorney Linda Bernard, P24740. I'm representing Mr. Deering on this matter. I would like to request the court for an adjournment. I was only recently received a copy of this file. I need to consult with my client to see if in fact we might be able to enter into some sort of resolution and or discover what the real facts are regarding this matter.
Thank you. Good morning to you, Mr. Bernard. It's a pleasure to see you this morning.
It's a pleasure to see you, Your Honor. Thank you very, very much. Especially during these times when so many people have been ill or passed away. Thank you.
These are very difficult times for sure. All right, council, there's a request for adjournment. This matter sounds like a reasonable request. I know we've adjourned it before relative to the need for counsel in this matter. Sir, your response to this regard.
So long as the appearance is filed, that's the only issue for me, Your Honor, is again, it's a pleasure to meet you as well. But yeah, it's the first time I've met her or heard from her on this matter. And this is what we were here for. It would have been, I was just waiting for an affidavit. It could have saved us some, or appearance. It would have saved us time with regards to this appearance today, but I have no objection otherwise.
Makes sense to me. Well, it's good that you guys didn't have to make your way down down to the building. It's good to see both of you this morning. Ms. Bernard, Madam Council, I've known her for probably 35 or 40 years, just the legal community, and that's why I reached out. I haven't seen her quite a bit of time. We've known each other for a long time. So, okay, I will go ahead and set the adjournment. The appearances set forth on the record. And, one of the things over the years of getting to kind of know, well, I know that Ms. Bernard was not here saying that she's representing somebody or she's not in fact doing so.
Of course.
Mr. Kim is correct to indicate that he'd like something by way of about appearance. The court also obviously the appearance should be generated copies of Mr. Kim.
Excuse me, Your Honor. I did file an appearance yesterday evening through the court. So I just spoke to Mr. Deering because the court had ordered Mr. Deering to obtain counsel. And so he just retained that. I did file the appearance last night through your court system.
Okay.
All right. Yeah, it hasn't populated to the file yet, but so how much time do you think Ms. Bernard need to get up to steam on this and communicate with Mr. Kim perhaps and see if this worked out?
It appears that there's been no answer filed in this case. I know that Mr. Deering did file his own motion. I saw where the court denied that motion to dismiss this matter. So there has to be an answer filed, and I need to have an opportunity to speak to Mr. Deering, obviously to return to court and be prepared to discuss this matter with you and obviously with counsel. And thank you, Mr. Kim.
Of course.
I don't think that I denied the motion. I don't think we got that far because Mr. Deering could not represent the corporation. So the motion to dismiss with failure to state the claim, the court has not ruled upon that matter because Mr. Deering could not go forward for the corporation.
Okay, because the I was looking at signed by you, it's just a written order. Actually, you have beautiful handwriting too, but it says the motion.
Ms. Bernard?
Yes.
Are you hearing me?
Yes, I hear you.
Okay, yeah, somebody chimed in and so it caused things to break up a little bit. You were saying something now. Start from where you were starting there.
And Mr. Kim may be able to help as well. I have an order dated 11/3/21 where it says motion to dismiss for failure to state a claim. Order, the motion is denied where the four corners of the complaint clearly set forth a cause of action for an alleged breach of contract that, if true, would entitle the plaintiff to relief as allowed by I can't know that word.
And Ms. Bernard, just to clarify as well, what we were here for was actually my motion to strike your client's responsive pleading in for default judgment. So that was the last hearing, and that's why the judge had mandated that he had retain counsel at that time. So frankly, we're basically back to square one with your presence. So I'm fine with just setting a deadline for when you will file an answer, and whatever the court deems appropriate and whatever you feel you need to do.
Yeah. And or argue that we can do.
I stand corrected. I do see that order that was issued back on the 3rd of November, denying the motion to dismiss for failure to state a claim. All right, and Mr. Kim reminds me, of course, that there was the motion for entry of default, and in lieu of granting the same, the court adjourned the matter so that the defendant could obtain counsel, and that's been done. So what I'm going to do is I'll set the matter 30 days out. I think I'm going to bring this back on April
you want to try the second week?
Yeah.
11.
April 11th, 2022, and that's going to be at 9:45 a.m. 2022, 9:45 a.m. I require that the answer in this matter be filed within the next 14 days. So that answer, so the answer in this matter should be filed on or before the 28th of March, 3/28, 22. And then I'm setting it on for a review hearing on the 11th of April, 2022.
Okay, Your Honor, just one question. Since Your Honor did not address the substance of Mr. Deering's motion that was filed in pro per, are we going to be prepared to argue that you filed a response to his motion, Mr. Kim? But obviously, I guess it wasn't argued. Is it permissible with the court for us to raise that issue now, or what is the druthers of the court?
Well, whatever rulings the court has made up to this point, those rulings stand. But any rulings that have been made are rulings that, of course, it doesn't have any prejudicial effect to them.
Okay.
Instead, the counsel wishes to raise, either side wishes to bring any motion before the court. The court will, in fact, will hear the same. In regard to Mr. Kim's motion that was filed requesting a default, the court will formally deny that motion at this time. Obviously, the court has set some requirements, and that is that an answer be filed by a certain date. If the answer is not filed by the 28th, of course, that would act as a default. The court would accordingly address issues at that time. What I'm going to go ahead and do you think that there is some, there are a couple of things I have in mind. One is to bring the case back quite soon to take a look at everything. Maybe the councils will have had a chance to talk and see if there could be any coming together to try to figure this out. And that would be in the short term. I would then set the matter out for discovery of issues along that line on the 11th. I would set up a calendar on the case. If you think I should do that now, then I'll go ahead and set a calendar now. My anticipation is that you get an answer, you take a look at things, talk about it a bit, and by the 11th of April, you have a conference with me, and we see where everything is. If you need a calendar, I'll set a calendar at that time.
Your Honor, that's acceptable to me.
That's fine with me, Your Honor. I figure that's actually a wise course of action.
All right, very well. So the matter is set as indicated, and then again, if we're able to make some progress at that time, it would be great. If not, I'll set up a calendar addressing discovery, filing motions, et cetera, on the 11th.
Okay,
Right, good to the two of you, and all the best.
thank you, Your Honor.
And I'll be reaching out to you, Ms. Bernard. Thank you so much.
I look forward to talking to you.
All right. Thank you, Your Honor. You have a good day. Be safe.
Good day. Thank you.
Thank you, Your Honor.
The court calls case number 22-177-174. This is Astera Credit Union versus Robert Lee Norton. The matter is before the court. It's like it's set on for status conference. I'll strike that. There's a motion for possession pending judgment, looks like, in this matter. Your appearance for the plaintiff at this time. Okay, now unmute yourself.
Please. Yeah, sorry, Your Honor. May it please the court, Your Honor, Stephen Bequicchio, P number 62076, on behalf of Astera Credit Union, the plaintiff in this matter.
All right, thank you, Council. Good morning to you, sir.
Thank you. Good morning to you.
I'm looking for Robert Lee Knowlton. If you're on the
Yes.
Zoom say this time.
Good morning.
Good morning. What is your name?
His name is Robert Noden.
All right, Mr. Knowlton, are you able to hear me this morning, sir?
Yeah,
Good morning to you.
good morning to you.
All right, and who is that that's with you this morning? Tell me who you are.
Marshall.
This is Catherine Noden.
All right, Ms. Knowlton, good morning to you as well.
Good morning to you.
All right, let's find out what's going on here. I see a motion for alternate services, things along this line. Council, update me on what's going on, sir.
Good, again, good morning, Your Honor, and Mr. and Mrs. Nowden, thank you for appearing today. Your Honor, we're here on a motion for possession in connection with a car financed by Estera Credit Union to Mr. Robert Nowden. It's an Infinity. Mr. Nowden has defaulted on that loan. Estera sought to exercise its rights of repossession as it's entitled to under its contract and under law in Michigan, was not able to do so for a variety of reasons, least of which being they could not locate it, necessitating this motion for possession to allow Esther Credit Union to obtain possession of the vehicle. The debt in question here is just north of $13,000. No payments have been made here, and Esther would like its vehicle so that it could exercise its sale rights and reduce that amount owed, which, as Your Honor is aware, is in both parties' best interests here.
All right, so Mr. Knowlton, Ms. Knowlton, the company that financed this vehicle, in this Infinity, they want the court to give them possession of the vehicle so that they can use that to pay towards an indebtedness that is outstanding on this matter. Tell me your thoughts about that, please.
Well, I don't know anything about it. And my brother, he been in the hospital since November. So I can't get any information out of him because his memory come and goes.
Okay, and so when you say your brother, you're talking about Robert Lee Knowlton, the gentleman that's sitting.
I'm talking about Robert Noden.
Yeah, that's the gentleman that's sitting next to you. Is that correct, ma'am?
Yes, yes.
So is he in hospital now, or you said he just got
Yes,
out of hospital?
he's still in there.
All right.
Yes, he broke his hip.
Okay, that's where you are now. Is that correct?
Yes,
So you said that he's there as a result of a hip injury.
yes. He didn't know what he was going to court for, so that's why I'm here.
Does Mr. Knowlton does anybody have any authority over him? Do you have guardianship papers, anything along those lines?
No, not yet, but I'm planning on getting them. But I was trying to see how long he'll be in here, so.
Okay. All right, Mr. Knowlton. Let me see if I can talk to Mr. Knowlton. Do you know what's going on with this case regarding the Infinity truck vehicle?
No,
I'm sorry.
You gotta say it again. He can't hear.
said no.
Right. So do you own an Infinity? Is that correct, sir?
No, I got it from my nephew.
He said he co-signed for his nephew.
Oh, is that what it is?
Yeah.
All right. So do you know where the vehicle is or anything about the vehicle at this time, sir?
No.
All right, can you think of any reason why the court, Mr. Nolan, can you think of any reason why the court shouldn't sign to allow the plaintiff to take possession of that car and try to pay this debt off?
What? I said what?
Can you think of a reason?
Reason why the court should not allow the plaintiff to take the vehicle and try to sell it to pay the debt off?
No,
I can try to find it because he been in the hospital and this is the first time I'm hearing about it and he didn't know why he was going to court. So I just put him on
Okay,
because
So
I take care of a lot of his business.
okay. So he doesn't have possession of the vehicle, true?
No. He don't even
So-
know where it's at.
Okay.
Your Honor, can I state something for the record here, Your Honor?
Counsel,
Your Honor, under the contract, there is no mention of a nephew. The primary obligor and the only obligor, as I understand it, is Mr. Nowden. I'm not suggesting that Mr. Nowden is not telling the truth here. Maybe he bought the car for his nephew. I don't know, but there's no co-signer here. Mr. Nowden is the primary individual responsible and liable for the indebtedness.
yeah, I was looking at the contract that was attached to the complaint, and I noticed in the contract that it was drawn up as to Mr. Robert Nowden. I didn't see any other person on the contractual agreement.
that's what first stood out.
He said when they went to go get it, that my nephew put his signature down there somewhere. So I don't know. I don't think he's telling a story. I don't think he don't know remember how it went. He's 75 years old, so his memory coming and going.
All
I
right.
understand, Ms. Nowden. And
So,
Your Honor, I don't
know.
think that's, I'm sorry, Ms. Nowden, go ahead.
No, I say I don't think he telling a story about it, but he probably just don't remember how it went because he was saying he co-signed. From his understanding, he co-signed for his nephew to get the car.
And I understand, Ms. Nowden, and Your Honor, for what it's worth, I don't think that issue is germane here with respect to the motion for possession here. We would ask, Your Honor, enter the order so that we could seek possession of it through a certified court officer. And Ms. Nowden, absolutely, if you're able to determine where the vehicle is so that we can get it, it will only benefit your brother because it will significantly reduce the debt that's owed to him. That's owed by,
Okay,
okay?
okay, because I would like y'all to have it back.
Thank you, thank you.
It's owed to y'all, so I don't think he's trying to take nothing from you. It's just that he don't know what his nephew did with it.
Yeah,
Absolutely,
understood.
that's
So if I
obviously.
can talk to his mother and find out where it's at and have you meet me over there at that address because he haven't been there since November.
Okay,
And have you to meet me over there if I can get a number or however it goes. So I can call you and have you or someone to meet me over there to get it.
Okay, we'll set
that's
up a way-
perfectly fine.
We'll set up a way to address those issues here as to why the court was drilling down and making the inquiry the court was making. Is the issues of competence, whether or not the defendant displays a sufficient degree of competence to be able to such that the court will be able to issue a proper order. And if there was something that was so incompetent where it appears that the defendant could not defend himself or did not have sufficient awareness, then the court could not issue the order regarding the recovery of the vehicle even at this stage. That's why the court was making the inquiry, not just to find out about personal lives and things like that. What was really clear to me from speaking with Mr. Nolan is that he was aware that there was a vehicle that he signed for an Infiniti, and he thought it was a co-signing, but he knew that he signed for a vehicle, and he says that it was for his nephew. The court further inquired as to whether or not Mr. Nolan could think of any reason why the creditor should not be able to take possession of the vehicle as an effort to pay the vehicle off or to try to satisfy some of the indebtedness. And Mr. Nolan indicated very clearly that he didn't think that there was any good reason why the plaintiff should not be allowed to have possession of the vehicle. Moreover, the defendant has the assistance of his sister, who has been helpful on the Zoom, and she's indicated that the desire Mr. Nolan would also be somehow make sure that this debt is somehow taken care of or satisfied. For that reason, I will grant the petition that has been offered, and that is the petition to allow for recovery of the vehicle pending the litigation or pending the outcome of the litigation. And I will sign an order consistent therewith, and that will allow, of course, for the vehicle to be picked up and seized for purposes of satisfying the indebtedness or the obligation. And Ms. Nolan has indicated that she might be able to assist in that regard. And I'm going to send both parties or both sides to the breakout room. I've already made the determination. Mr. Counsel, you may send your order in. I don't think that there was one. Well,
Your Honor, there was, as Exhibit B, we submitted a proposed order, which is consistent with your ruling today.
Yeah, I do have that order, having looked through the file. The court will sign that and we'll get that out right away. And that will conclude the hearing in this regard. I will set up now for you, counsel, and the other side to go to a breakout room to talk about logistics that might be helpful.
Thank you, Your Honor.
So, ma'am, you're going to receive a notification to go to breakout room number 1, together with Mr. Nolan, and counsel is going to be there. You can talk about logistics that might be helpful getting this resolved. All right, okay, to each side, there's your notification, counsel, and here is your notification, Mr. Nolan and Mr. Nolan.
Thank you, Your Honor. I'm joining now.